Welcome to the most important week of the year for the podcast industry. Welcome to Podcast Movement 2025.
Hey everybody, welcome. This is Two Truths and a Lie Podcast Law Edition.
The only game show you will ever see two lawyers admitting to telling lies.
So what we're going to do is we're going to bring up a couple of contestants here.
Or we can call, too. Maybe we can do both.
Oh, maybe we'll just call on people in the house. Okay. All
Right,
right.
exactly. So we are going to read questions, right? There'll be three things, two truths and a lie. You know how this is done. If you think you know the answer, raise your hand and we'll call on you. Put you on the spot, so you don't have to come on stage.
Right on. All right, and at the end of our time, we will declare a winner and share some beautiful prizes.
Yeah, 1 point for a right answer, no points off for wrong answers, SAT rules. And the prize, what are the people going to win today, Gordon?
Well, a free membership in the Easy Legal for Podcasters course and templates system that helps you get your legal stuff done for yourself.
So Gordon has a full set of legal forms to for any starting entertainment person, but also podcaster for sure.
Yeah.
I got nothing. So from me, you will win an hour of free legal work, which might not be a prize, might be a penalty. I don't know.
You get what you pay for.
Yeah, exactly. Okay, question number one. Let's introduce ourselves.
Oh, I'm Gordon Firemark. They call me the podcast lawyer. Been practicing entertainment law for 34 years, and podcast law as long as there's been such a thing as a podcast. So it's exciting helping creators accomplish their goals, achieve the impact, income, influence, those kinds of things.
I'm Lindsay Bowen. I am not the podcast lawyer. I am a podcast lawyer. But I've been working with podcasters since about 2016. At one point, everyone in podcasting was either my client or his in the early days.
Yeah.
I ended up going in-house with a client, which got bought by another client, which I encouraged to buy a third client. That is now SiriusXM Media. So for a while, I was their head of business affairs. I've been out on my own and again for 2.5 years with sort of a values-based law firm. I work mainly with production companies, small networks, ad tech companies, and creators, and so incredibly happy to be doing that.
All right, we have very short time, so we're going to jump right in with questions.
Let's go.
First question. The topic is guest releases. Here are the three choices, two truths and a lie. A, you can use a guest's voice and words however you want once they show up to be interviewed. B, without a written release, guests can demand their episode be taken down pretty much at any time. Or C, it's okay to use AI to clean up audio, but not to alter words or tone without permission. Anybody? Which one of those is the lie? Amanda. A. That's right. Consent to be interviewed is not a blanket license. Just showing up is not enough. Consent.
And tell us your name for posterity. Thank you,
Okay.
Amanda.
Hey, Loyalty, could you sort of keep track of who's got points too?
Yeah, so we got Amanda with 1 point.
All right.
Who's next?
Okay, next question. This category is podcast distribution and sales contracts. Two truths and a lie. A 70-30 rev share deal is industry standard for host-read ad sales deals. B, a minimum guarantee is the same as an advance. And C, certain costs are always recoupable. All right, where's the lie? All the way in the back.
All the way back. Only one hand went up on that
Now,
one.
I've got a podcast salesperson here. Oh, what's your name?
Amber.
Amber. Nice to meet you, Amber.
It was B is the false one?
Actually, it is C. Certain costs are always recoupable. And this was really hard on purpose, right? So if you are a creator signing with a network, they'll say, oh, these are standard costs. They're always recoupable. Not necessarily. You could say, no, I'm not paying for marketing costs unless I approve them. No, production costs aren't recoupable. No, what you're paying your host platform, Mrs. Network, is not recoupable because you'd be paying that anyway. So that's a point you should always negotiate when you do a distribution deal. But thank you very much. There's always got to be somebody to get the first question wrong, and it feels hard, but it's not hard. Gordon got this one wrong, actually, during rehearsal.
Hey, now. The word always is a challenge in these kinds of things. So, anyway. All right. Next question. Limited liability company and business structures. Limited liability companies protect personal assets from lawsuits. That's A. B. Filing in Delaware is the best place to file. And C. LLCs help manage income and taxes professionally. Who's got the lie in there? The chicken in the second to last row.
Well, what's your name first?
My name's Amy,
Hi, Amy.
and I would say B is the
That is the correct answer. Delaware is great for large companies. They have very favorable laws for companies with big boards of directors and lots of shareholders and things like that. But often it's overkill for smaller businesses until you're getting to a pretty significant size. And then Delaware starts to have some advantages. So nice. Thank you, Amy.
We have a tie. By the way, a round of applause for our scorekeeper who did not
Loyalty.
know she'd be doing this and is great at it. What's your name, ma'am?
I am Miss Loyalty.
Miss Loyalty, the scorekeeper. Okay, question number 4. This is my favorite topic for podcasters, fair use. So yes, everyone's a lie in this. It's not. 2 truths and a lie. Find the lie. A, using a clip of over 1 minute can be fair use. B, using a clip of under 30 seconds can be fair use. C, using a clip of under 15 seconds is always fair use. Oh,
we got-
chicken was, well, what do we do? Chicken was first.
That was that first hand up.
Using a clip of under 15 seconds is always fair use. Yes, that is incorrect. Now, to tell you, first of all, Gordon gave it all away, which is fine. Look for always. That always is always wrong. Never is always wrong, for sure. But there is no safe harbor in the U.S. or U.K. A fair use or fair dealing law. A lot of people think this for some reason. So if it's short, it still could be violating the other factors of fair use. If it's long, you could have a 15-minute clip of something that's Joe Rogan's podcast, let's say, and if it fit every other factor of fair use, it could still be fair use. The length of time by itself is not a determinative factor. See our millions of other panels on fair use,
Yeah.
including last year in Chicago, for more information.
Yeah, the thing about fair use is it's really not something one should rely on unless they're really, really certain what they're doing, because it's a case-by-case analysis of these 4 factors, and by the time you get to really talking about it, you're doing it in front of a judge, and that ain't fun or ain't cheap either.
Fair use is the right to hire a lawyer. There are several successful podcasts that have me read scripts for every episode and read outlines for every episode arc to advise them. And even that is way less than they do in film and television, where someone is watching or listening to every second.
All right, our next question in the category of co-hosts and partnerships. A, verbal agreements between co-hosts are legally binding, however risky. B, if a co-host quits, they may still own a part of the show. And C, you don't need a written agreement unless you're monetizing your show.
Ooh, Amanda was first.
Amanda's first hand up.
A is the lie.
No. The correct answer is... Oh, someone else can do it. Yeah.
Actually, Chicken Hat I'm sorry, Amy was next.
We're doing it in the order the hands go up. So
You guys, it's Jeopardy.
we didn't have a buzzer. So C, you don't need a written agreement unless monetizing. That's right. Written agreements are a smart thing from day one. Ownership disputes happen just as often before money gets involved. Money just makes them louder.
So what is our score tally thus far?
Amy is at 3. And we have our other one up there at 1. Okay, so yes, Amy's in the lead right now, y'all. So I need y'all to answer some questions. Okay.
Yeah, jump in, folks.
And we're going through these pretty quickly. I'm going to go back
We've
and
got a few
explain
more, so,
one that I
yeah.
didn't do, but we've
Go
got
ahead.
a few backups too. We can really hash this out. The game, it's not anybody's game yet. So, question number 6. Contract boilerplate. That's all the boring, terrifying stuff at the end that, as Gordon says, lawyers put in to make themselves look smart. So, A, The parties can choose any state or country's law, even if neither one lives there. B, a creator should never sign a binding arbitration clause. There's that word never, but maybe this one's a trick. C, lawyers hate shared copyright ownership. I knew this was a hard one.
No takers?
I mean, there's
Read
a
them
1 in
again,
3
Lindsay.
chance. There we go. Back on the board. Amber.
I feel like it has to be A is false.
This is a really hard one for a reason. I wanted someone to pick that one so I get to talk about it. No, when you are signing, I have several UK clients, and I have several clients who do business with UK companies. You can pick any state or any country's law to say this contract should be interpreted under the laws of Delaware, New York, where I'm from, California, where Gordon's from. Hey, Gordon, what state's law do you prefer?
Nebraska. No, California.
Yeah, and I prefer New York law because I'm in New York. The state contract laws are slightly different, but sometimes these slight differences can be in your favor. For example, under California, the state law says that the word reasonable can be assumed to be in every sentence, right? You can make any reasonable increase. You can make any reasonable change.
Which is a perfectly reasonable assumption, right?
Yeah. And if you're signing a contract with, I'll go ahead and say it, SiriusXM, who hates to have the word reasonable in their contracts. I was in-house, I know that. Get California law, and then you've got that word every time.
Yeah, I've seen, I actually just did a deal recently where we chose Singapore law because one client was in New Zealand, my client was in New Zealand, the other side was in Vietnam, and they wanted it to be neutral territory where it would be sort of equally hard for either of them to go to court in the first place.
Now, we're out of the first prepared questions. We're going to take a second to confer and check on time.
Yeah. We've got about 2 more minutes left. Should we-
2.5. 2.5.
Okay. Subject is libel.
Sorry, the right answer there. I'm sorry, that was also, thank you very much.
Right.
Also important, a creator should never sign a binding arbitration clause. That is wrong. A binding arbitration clause, you've all read about it in the news. It's horrible when you're doing a deal with your bank or your credit card company and it's like a political hot button issue. But in a contract, all it says is, if we have a dispute about this contract, we don't want to go to court. We're going to hire an arbitrator instead, which is really cheap, much cheaper, and more confidential. It can actually be really good for both parties. I see creators a lot saying, oh, I've heard of this in the news. I don't want to do it. It's a common misconception. Thank you so much. You
All
get
right.
half a point.
Subject matter is libel and defamation. A.
This is the final question.
You can be sued for defamation for podcast statements. B, truth is generally considered a complete defense. Or C, if you don't name the person, they can't sue you for defamation. The journalist in the group.
The first gentleman.
Oh, God, you've just said the journalist in the group. Now I'm going to get it wrong. C.
That is correct. If the person can be identified, whether you name them or not. So if you're talking about your ex-spouse on a podcast episode and you say something about how they abused you, you don't have to give their name. If they can be identified, that can be a real problem. And it actually is a pretty common problem I'm seeing.
Oh, wow.
Amber has a question.
Wait, I've actually thought about this. Okay, so I guess what if you had 2 ex-spouses? And technically, theoretically, it's not, or I guess if you're talking about a coworker, but technically you have multiple coworkers. So people who know the story know, but it could be multiple people. How does that work?
The way that works is everybody hires lawyers and you go to court and you have a big expensive trial where the person tries to prove that no, it had to be me. Everybody would have known it was me.
I was doing a fair use and defamation review for a podcast recently where the members of a team of engineers, somebody on that team did this terrible thing that caused someone to die. That was enough, right? So that's more than 2 ex-spouses. Can we have our final tally, please?
All right, so we have to give it up to Miss Amy, but I want to shout out the A's because the A's showed up. We had Amanda, we
Yeah,
had Amber,
that's
we
right.
had Amy, and our one gentleman. But yes,
Yeah.
she won.
So,
And a journalist. They were all A's.
Yes, all A journalists.
so congratulations, Amy. You're the winner of the course, the Easy Legal for Podcasters course. And everybody else who participated, let's do a runners-up prize of we'll each
Sure.
offer you a consultation.
Right. So everyone who participated gets a consultation. Amber, I'm afraid you get sort of the booby prize, which is an hour and 5-minute consultation with me. So
Oh.
the extra 5 minutes is your punishment.
You have to use the whole thing. Yeah. All right. Hey, thanks everybody for being here. I hope this was fun.
Thank you very
All
much.
right.